Welcome to another episode of the Sharkcast on litigation risks management, where we explore why businesses are so frequently sued and how to mitigate and navigate the dangers lurking in these risky waters. Join us now as we welcome our host, Kent Schmidt, litigation partner at the law firm of Dorsey Whitney.
Thanks for joining us for another episode of Sharkcast. I'm very pleased today to welcome to the podcast virtual studios a longtime friend and partner, Mike Droke, and a relatively newer friend and colleague, Nathan Webster. Mike Droke is one of our partners in our Seattle office, and he wears many hats at the firm, one of which is pertinent to our conversation today, and he is the firm-wide co-chair of about a 200 plus lawyer group called the Food, Beverage, and Agricultural Industry Group. And so we're going to be talking some about food and beverage. Mike and I both enjoy food and beverage and enjoy talking about food and beverage. So welcome, Mike, first of all, to you. Glad to have you on the podcast.
Glad to be here.
Long overdue to get you.
I know. Yeah, we talked about it before the inception. So
yeah,
exciting to see the success.
And Nathan Webster is an associate in Dorsey's Regulatory Affairs Group, and he is in our Minneapolis office. And what that means is that Nathan enters the regulatory thicket to try to figure out what the regulators are doing and what that means for businesses in terms of compliance. So thanks for joining us as well, Nathan. We're going to be talking about some regulations today.
My pleasure, Ken. Thanks for having me.
So today we're going to be talking about PFAS. And that is a topic that has garnered a ton of attention in recent months and years. And, you know, sometimes you hear that something's going to be the next, litigation tidal wave and ends up being much ado about nothing. But I think PFAS has real staying power when it comes to a litigation risk. And so what I'd like to do is approach it from both a litigation standpoint and a regulatory standpoint. And as I write and speak about litigation risk, I often emphasize that these go hand in hand. It brings to mind a great quote, and we'll see if who among our guests, between our guests, might know who said this quote. I think you'll know it just by me saying it. I skate to where the puck is going to be, not where it has been.
Wayne Gretzky.
Do you want to take a guess, Nathan?
You know, I'm more of a Wimbledon fan, so this is a little bit outside my wheelhouse.
Okay. It wasn't a tennis player, I'll say that. You know, you're very close, Mike. It wasn't Wayne Gretzky. It was Wayne Gretzky's father. I think it's cool that he always attributes that quote to his father. But the relevance of that quote when we're talking about regulatory risk is that if you want to avoid certain litigation claims, figure out what the regulators are doing. Because of what the regulators are doing today, the class action lawyers are going to be doing tomorrow and the day after that and the day after that. And so we want to look at what is happening and has happened on the regulatory landscape so that we can understand what is going on and what will continue to be evolving on the litigation landscape. Essentially, we want to focus on where the puck is going to be in terms of PFAS litigation risk. So I think that's a good reminder and an important thing to think of just outside of PFAS as well. First of all, before we jump into PFAS, any thoughts about the interplay between regulatory changes and litigation risk in other contexts as well?
I think that's a great point, Ken. And we often see plaintiffs' attorneys identifying businesses that are being regulated as their next target, because typically regulators don't focus on something unless there's some kind of risk of harm. And with respect to PFAS specifically, a lot of those records the regulators are collecting are actually public, and so sometimes plaintiffs' attorneys use Public Records Act to drum up their next set of cases. So I think you're right on point there.
Well, it's really two things, isn't it? It's what are they prohibiting and starting to set standards on? And then it's the regulatory actions where they slap a regulatory fine on someone or on a company. And then that becomes the predicate for consumer class action as well. So you need to be very cognizant of what regulators are doing on both the promulgation side and the enforcement side.
I looked at just a couple of nuances there. Especially something like PFAS, where it's unclear what it is and what the risks are. The regulators' actions will really validate some of, or try to validate some of the science around it. And so it makes the claims easier to prove in a way. And then likewise, as Nate was saying, if you have somebody who's the subject of a potential investigation or the like, then the plaintiff's lawyers can use that to have basically free discovery through the regulatory process to help jumpstart their claim or potentially to vet whether there's a potential claim. So I think it comes in a variety of different ways, not just PFAS, but really any kind of new regulation.
Oh, and I was just going to add, often in the environmental litigation space, the prelude to a big consumer class action is a regulatory enforcement action. So you see that a lot in toxic environmental class action disputes. So I just wanted to second that.
Yeah, for sure. Okay, so let's jump into a discussion on PFAS. Nathan, why don't I put you on the spot here to give us, without geeking it up too much, what is a workable layperson's definition and understanding of PFAS?
So PFAS literally stands for perfluoroalkyl or polyfluoroalkyl substances. At its core, these are substances that are extremely strongly bonded together. They are heat resistant, they are water resistant, and they are resistant to grease and other stains. And so they often feature in products where those qualities would be useful. But at their core, they're just very strongly bonded heat and grease and water resistant substances.
And are they are PFAS manufactured chemicals, or are they naturally occurring?
They are manufactured. A lot of companies have made a lot of money manufacturing these substances to lend marketable qualities to their products. And so considerable time, effort, and expense has gone into producing these. But just because they are artificial does not mean that they disappear, that they're not now a feature of the natural world, because they very much are.
Okay. And let me just truncate one part of PFAS that I just want to say at the outset is an important component of understanding PFAS regulatory issues, but is too specialized for us to go into today. And that is the water contamination side of things. We have a very broad audience here at SharkCast, but I'm not sure how many listeners we have that are in the, water treatment waste facility in that area. But that's a whole world of PFAS that sort of lives into itself. And we're not going to be digging into that. We're going to be instead, and there's also another world of PFAS, which is sort of like stuff in the air, in the ground, not even necessarily water, but sort of the environmental side of PFAS. What we're going to talk about today is how PFAS liabilities arise in the consumer products space. So when you buy either a food or beverage, or you buy cooking utensils, or you buy other types of products that are outside those initial categories, the liability that arises, and hence the concern that companies that are manufacturing and selling those products should have for PFAS litigation. So who are the companies that should be most concerned? Maybe Mike, you can tackle this.
Yeah.
The first wave of litigation claims over the last couple of years sort of identifies the category of companies that should be most concerned about PFAS.
Absolutely. And I think Nate did a great job of kind of explaining the use cases of a PFAS material, because anything that would, as he described, benefit from having, it not gather grease or the like, those are the kinds of companies that should be really thinking about this. And so what we found as far as the litigation is concerned, this is the early stage of the wave. But we have definitely seen that companies that manufacture things that go on the body for a longer period of time. So that could be, lipsticks, balms, creams, that type of thing. Potentially clothing wear of various kinds. If it's using the materials, then that would be a company that would be considering it. Food products to some degree. I say to some degree because the quantity of intake might be different if it's temporary. And then really anybody in the chain of distribution of those products. So it's from the manufacturer where the products began all the way through to the retailer at the end of that spectrum.
And particularly, if I could just append to that, it seems like there's as much of an issue with PFAS in food containers and packaging as there is in the food itself. So maybe the food is completely clean and pure and free of any PFAS, but then you put it into a plastic or other
Clamshell
type
or
of container, then you have a problem.
exactly.
Let's now talk about some of the litigation claims. What are some of the theories of liabilities, and how are courts sorting through the plausibility of the science? And let's also talk in connection with that, unpack this very challenging concept of how you test for PFAS. And how you determine whether a product has PFAS, and then the plausibility requirement for a plaintiff bringing a claim. Who wants to tackle that and give us an overview of how these cases are being brought and how they're faring in federal courts?
I'm happy to talk about the theories that people are using generally. So I would categorize broadly the consumer classes into two larger buckets. One is the actual contamination bucket. You put PFAS in this food container and it, it's potentially causing harm to me from a cancer or health perspective. But then there's also I believe, a larger and more indeterminate class of kind of consumer deception claims, consumer fraud claims. Basically alleging, you sold this product and you said it was healthy, or you sold this product and you said it was uh, environmentally friendly, and it turns out it has PFAS. And so under whatever consumer statute or whatever common law theory of fraud or some other cause of action that sounds in fraud, you've deceived me and I've paid more for this product than I otherwise would have. So those are kind of the two main fields that I see in terms of the consumer class. Mike, I don't know if you see more out there.
I a little bit more, but first, kind of echoing your comment that what we're seeing are what I would call standard garden variety claims in the consumer liability world that are now being applied into this new vertical of the science, and that would include Nate, the claims that you're describing. I would also put in there labeling claims, potentially Prop 65 claims. So anything there that is a standard claim where the lawyers know the pleading standard and what facts they need to gather for that kind of a lawsuit, and then they're adding the PFAS overlay into it.
Let me just point out another thing that I'm seeing in these cases that are emerging is how much certainty and plausibility, to use the technical word that's used in federal courts, is required for a plaintiff to allege that a product has harmful levels of PFAS in it. And let me just unpack that a little bit. PFAS is incredibly difficult to test for in terms of its presence. And Nathan, you might be able to break this down a little bit from the science standpoint as to why that is. You can't just run a PFAS test because of all the varieties of PFAS and all the ways in which PFAS exist at almost non-detectable levels. And so there are these tests that exist that are rough proxies for the presence of PFAS. And I'm thinking, for example, of the total organic fluorine method that is endorsed under some statutes and by some regulators, but not others. And so the question is whether or not testing for the presence of for total organic fluorine is sufficient to meet the Iqbal-Twombly standard of plausibility. And I think that concept, the intersection of Iqbal-Twombly plausibility and these proxy tests, it's causing some federal judges to sort of pull their hair out, isn't it?
You know, I'll start with that one, and then maybe you can go into some of the testing issues. For non-lawyers listening in, Iqbal-Twombly is the standard of pleading that's required to have a case survive in the federal court system. And that's important in these kinds of cases because we're still really early on in the litigation wave, as it were, meaning that many of the cases that have been issued are either at the lowest court level, so the district courts issuing an order about the pleadings themselves, but really without facts having been proven yet in the case at all. And then some appellate cases, but again, all of it happening at the pleading stage and before the real litigation process and proof aspect has occurred. So what I've been seeing is that it's, at least at the pleading stage, a pretty low bar as far as being able to, if there's some evidence to support the claims in the complaint, then that isn't the hurdle that is necessarily happening in some of the cases. What is happening is that there are facts around what claims were made, like Nate said a minute ago, about healthiness. Well, that we can kind of grab onto, or claims about, chemical free or anything like that. Then that's what the focus of many of the cases have been.
The flip side of affirmative misrepresentation cases relating to the purity of the product or the lack of presence of PFAS are cases that are built more on the omission of information relative to PFAS. Mike, do you have any comments on that?
Yeah, so what we're finding is that the case law theories that apply generally to product litigation are being used to address claims involving PFAS. So just recently, literally a couple of weeks ago, for example, a decision was issued in this area, borrowing again from other consumer-based claims. And what the court held was that this concealment theory could apply if one of four things occurred. First, that the company that manufactured the product was in a fiduciary relationship with the plaintiff, the person allegedly harmed. Second, that the defendant had exclusive knowledge of material facts not known to the plaintiff. Third, that the defendant company had actively concealed a material fact from the plaintiff. And then fourth, that there were partial representations, but that the company manufacturing the product had suppressed material facts that were not unknown to the consumer.
So those are some pretty broad standards that, can be at least argued past the motion to dismiss in many cases. In many cases, of course, the fiduciary duty is usually not going to be relevant here. It's usually not a fiduciary obligation, but the active concealment or just disclosing partial facts. So if you have a fact sheet on your website and you start talking about some environmental exposures and some safety issues and maybe even approach PFAS, what are the additional facts that might have been omitted that have now led to a claim of concealment or fraudulent non-disclosure in a connection with the sale of a product? Very slippery slope there, and it makes for a challenging compliance or litigation avoidance strategy of, you know, what are you to do? How much do you disclose, and when is enough in terms of a full disclosure? Let's turn our attention a little bit to talking about this topic, which we always try to conclude our discussion with, which is litigation avoidance. I know that we are hearing from clients constantly about demands that are made by their customers for PFAS compliance, whether or not this can be insured, you know, reps and warranties that are made in the business-to-business context, and indemnity. Either of you want to tackle that concept and what we're seeing on that front?
Yeah, I can talk briefly and see if Mike has anything to add. So from a regulatory perspective, numerous states actually now require reporting PFAS in your products, and many of them require actually going down your chain of distribution and acquiring affirmations from your suppliers that there are no intentionally added PFAS in the components they're supplying to you. So that's actually quite an extreme level of diligence that some clients are facing, and it's quite an onerous, expensive process to comply with that. Other regulations aren't quite as onerous. They just require best faith efforts. So that's just a regulatory perspective there, just complying with mandatory reports. But from a litigation perspective, certainly there has been an increase in demand for environmental indemnification clauses in your contracts if you're dealing in an area that might have PFAS. There's a really relevant insurance question here. A lot of the times there are environmental clauses in insurance policies that you might, you know, a lot of clients might have environmental exclusions they don't know about in their policies, and they should try to renegotiate if they're in a space where this might be an issue. This is all to say, yes, there's an increase in demand on the legal side to investigate those kind of indemnity and contribution clauses. But if you haven't noticed it yet, you should be looking into it if you're in an industry that might have these issues.
Mike, are you seeing clients that are raising these issues, either asking for advice on how to get PFAS assurances and certifications and indemnity, or that they're on the other end, they're receiving such demands from those in the chain of distribution?
In the food area, and in particular, the clients that we represent, often they're getting both. They're getting the retailer's demand for indemnification, and they're seeking back through the chain of product distribution and the like. I think definitely the insurance issue is something that's of serious concern. And one of the challenges that in the food distribution world, but really any company that has something that could be PFAS in their system is how to test for it. And so, Nate, I'd love if you could circle back to that question and let people know what's involved with PFAS compared to other kinds of potential contaminants.
So the main distinction that PFAS has is that it's actually quite hard to specifically test for PFAS. There are proxy tests you can conduct for, you know, parts per million of total organic fluorine, and that gives a rough approximation, or not an approximation, but it signals that there may be PFAS present, but it's not an entirely accurate test, and the FDA and regulated parties haven't really settled on a perfect test for PFAS. That's not to say that regulators aren't running with that proxy. I know for a fact that states like Minnesota specifically adopt the parts per million of total organic fluorine as the default test for whether you need to report PFAS in products under their regulatory schemes. But that is an ongoing issue. And it's not to say a plaintiff's firm isn't going to sue you. if they've run that test, they'll probably charge right ahead. But uh, it's also a potential defense if you can come up with a more reliable test that could countermand any problematic readings under those testing procedures.
Let me just throw out something that I've been toying with in this area, and that is when you have a party that's sort of caught in the middle between the end seller, say the product label that's going to be putting it on the food on the shelf, and say they're the manufacturer of the packaging. One thing you can do is say, look, these statutes talk about intentionally added PFAS. I can assure you, I'm not intentionally adding PFAS. I want you to be the one to certify and sign off on your raw material supplier that I'm going to use to create your packaging. In other words, I don't want to be caught in the middle. You select what polymers or plastics or other materials are going to be used, and you do your own due diligence to determine whether or not they're PFAS free to your satisfaction, but don't look to me to do that. So sometimes the up the chain initial reaction that we tend to think is the way it should go can be disrupted by a party saying, hey, look, you're the one that's ultimately going to be sued in the consumer class action. You need to sign off on all of the raw material suppliers, including the packaging supplier, and then I'll do your bidding. So there's a lot of pulling and pushing that goes on. And the more that you think about these issues well in advance, the better off you'll be when that class action or pre-lawsuit demand letter, comes across the transom.
You're right, Kent. There is a game of hot potato going on with respect to the PFAS potato. We've seen a lot of scurrying around the chain of custody to try to ascertain who is responsible for reporting on what. And yeah, I think being proactive is the only way to go about it, because someone's going to come after you with an indemnification claim or a contribution claim if you haven't thought about it beforehand.
Yeah. Well, before we conclude our discussion on PFAS, Mike, would you just give us a summation of what the one takeaway is that companies should be thinking about when it comes to PFAS liability?
Well, my one takeaway is that the topic of PFAS really has to be at the executive and board level and discuss these very issues that we've been talking about here, as far as the kinds of liability that could occur if there's PFAS in your product or if it's in the distribution chain, and all the various departments that have a piece in protecting your company from litigation for PFAS.
Very good. Well, that's about all the time we have to discuss PFAS today. As fascinating of a topic as that is, there'd be a lot more that we could dig into. But we're now at the point in our show that we like to learn a little bit about our guests as individuals beyond their life and role as lawyers. And so I like to spring an unrehearsed question on our guest today and see what their answer is and learn a little bit more about them outside of their role at Dorsey. So why don't I start with you, Mike? If you had not decided to become a lawyer, what other career path do you think would have been as invigorating and rewarding and challenging as your life as a lawyer? Either one that you contemplated at the time,
Yeah.
but reluctantly chose the field of law for better or worse, or one that in hindsight, yeah, that would have been interesting.
Yeah, it's an interesting question for me personally. I was a human resource manager before I went to law school, and I actually went to law school to move up the chain in human resource management. I was not intending to be a lawyer. And it wasn't until about halfway into law school, I thought, wow, I really enjoy this, and I've loved it ever since. So nothing else that I'd prefer to do, but I probably would have continued to move up through the chain of human resource management. That was the trajectory I was on for sure at the time.
All right, Nathan, how about you? Did you take a good, long, hard look at any profession other than becoming a lawyer?
It's so funny. So my mom is a physician, and I really wanted to be a physician. And she said, if you become a physician, I will not help you in any way with college. Do not become a physician.
Wow.
And I think it's funny because so many lawyers tell their kids, do not become a lawyer. I wouldn't say that to my kid, but it's just funny how that how that echoes through the various professions. But yeah, I thought a physician would have been a fun thing to be. I'm told I don't have a good bedside manner, and so maybe some kind of surgeon where they're unconscious. But I also don't like blood, so maybe it's a good thing that I ended up in the law.
All right. One more deeper dive question for each of you. We're nearing the summer months. Any plans either for interesting places to go this summer, or if not, the alternative question is, what's sort of on your bucket list of a place to visit that you've never been before, but you really hope to get to?
Well, I'll go first. So definitely on my bucket list is Argentina, and I don't know why. I speak some Spanish. I'd love to take a Spanish immersion course, and that would be, for me, a month-long Spanish immersion somewhere like that.
That sounds fun, and I think really good food too, right?
So continuing on the Latin American or the Spanish speaking trajectory here, I am going to Spain this summer to see the total eclipse of the sun on August 12th. My friend asked if I wanted to go kind of on a lark, and I think by August I'll be in need of a vacation, and so I said let's do it. But I've never seen one before, and apparently it's quite life-changing. And I've never been to the Iberian Peninsula and also studied Spanish. So I'm excited to use my Spanish because I don't use it much in Minnesota, to be honest.
Terrific. Well, I wish you both on the best on those trips to Argentina and to Spain. They sound like a wonderful time. Well, thank you both for joining me for this discussion of PFAS on SharkCast. And with that, I'd like to thank our listeners as well for tuning in. As always, I'm indebted to the extraordinary team at Dorsey for making this podcast and this episode possible. For more resources on this and other litigation risks, go to litigationrisks.com, where more information can be found, including a book on managing litigation risk written by yours truly. Until next time, my friends, this is yet another reminder that there are a lot of sharks swimming out there in those murky waters. So swim safely.
This podcast is not legal advice and does not establish an attorney-client relationship or create any duty of Dorsey Whitney LLP or those appearing in this podcast to anyone. Although we try to assure that the content of this podcast is accurate, comprehensive, and reflects current legal developments, we do not warrant or guarantee those things. The opinions expressed in this podcast are the opinions of those appearing in the podcast only, and not those of Dorsey & Whitney. This podcast is considered attorney advertising under the applicable rules of certain states.